Assalamualaikum warahmatullahi wabarakatuh. This is our Zoom recorded lecture for the topic consideration for the course outline. If you refer to your course outline or our syllabus, this is the fourth topic. Okay, we have covered offer and then followed by acceptance, and then we also discussed about intention to create legal relations. So this is our fourth topic, and the topic is consideration. Let's have a look what I have prepared here. Okay, meaning that here, despite the fact that we have, the parties are able to prove to the court that there exists a valid offer, a valid acceptance, and also there exists intention to create legal relation between them. But here, it does not really create a valid or enforceable contract between them. Because why? Both of the contracting parties, okay, they must prove to the court that they have actually given or exchanged consideration. Okay, then only the contract between them is considered as valid and enforceable. So what does it mean by the word they must provide consideration here? So basically, both of the parties, offeror, offeree, okay, each side must promise, okay, to give or do something for the other. So it's exchange of the things, okay, to be done for both of them. Okay, let's have a look at the examples here. For example, if A is the promisor or the offerer, promises to clean the house of another, that is B. Okay, meaning that here A said, okay, I'll clean your house, B's house. So B is the promisee or the offeree. Then how do we look from the perspective of consideration? So A's promise here, okay, will only be enforceable, will only be valid in the eyes of law, okay, if B also has provided consideration, okay, to be given to A. Okay, there must be consideration between them. And then usually consideration from B, okay, usually in the form of payment of money, okay, while A provides service of cleaning here. Okay, whatever service of cleaning or whatever kinds of service which is relevant, which is acceptable, okay, on the part of A. And then even though, okay, the promise of money payment here for the service provided by A here, and promise of payment of money to be given by B, it is to be done in the future. Meaning, okay, I'll pay you once the cleaning is done. So is it valid? Is it sufficient? Yes, it is. Okay, it is just as sufficient a consideration or payment as actual rendering for the service. Meaning that here service will take place first and followed by consideration or money payment by B towards A later in the future. So yes, it is valid, it is legal, it is enforceable in the eyes of law. So now we go back to the question. Okay, we haven't discussed what's the proper definition of consideration. So what is consideration? How do we define the word? So there are two possible ways of defining the word here. First, we go to the case law, or we call it this is the the interpretation from case law. This is the traditional definition. It was created, or it was actually proposed by Lash J. Okay, the judge name is Lash. In the case of Curry and Misa, reported in the year 1875. So what did he say here? He said that a valuable consideration, okay, in the eyes of law, from legal perspective, it may consist either in some right, interest, profit, or benefit accruing, okay, moving to one party, or on the other side of the party, some forbearance, detriment, loss, or responsibility given, okay, suffered or undertaken by the other. There are exchanges of things here between the two parties. Let's have a look at the interpretation or definition given by statute, our own statute, section 2D, Contracts Act 1950. Okay, let's have a look at here. Okay, 2D, it is stated here, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something. So whatever arrangement, whatever promises here, okay, whatever agreement here, so such act or abstinence here, or promise, is called consideration for the promise. So this is the statutory definition of the word consideration. We go back to the slides. Okay, we go here. Okay, now let's have a look at the rule, okay, or principle governing consideration. So what's the principle here? So in all agreements, okay, it needs, it has to be proved that there exists consideration between the parties. So the rule is that agreement without consideration is void. So in other words, all agreement must contain consideration. So it follows that a bare or gratuitous promise here, which means that a promise not supported by consideration, so it's not enforceable, it's not valid in the eyes of law. So you can't really enforce it against the other party here. And then another relevant section, other than section 2D just now, we also have section 26A. We are going to discuss about this section later, but let's have a quick look on section 26A. Basically, it provides for the above rule, but as usual, we have general rule, and to balance the rule, we also have the exceptions. So we have specifically 3 exceptions under subsection A, B, and C. Let's have a quick look on the section 26. Contracts Act. We have to scroll down, okay, 26, 20, 25, okay, 26 here. Okay, the title of the section here, agreement without consideration, void, unless, meaning that here it will be valid in these 3 circumstances. So agreement without consideration is void unless first it is in writing and registered. Or we are going to have a look at it later, okay, with all the case law, or it's a promise to compensate for something done, and or is here in alternate, or is a promise to pay a debt barred by limitation law. So in any of these 3 cases, such an agreement is a contract. We are going to relook at the section later. Okay, let's go back to our slides. Okay, another issue that we need to consider or discuss here, contract as compared with gift. We also have another term which is called gift, or if it involves parties, usually whenever it relates to a gift, we have the term like dono and doni. Dono is the one who give away, doni is the one who accepts, okay, the gift or donation, right? So basically, these 2 terms are comparable. They are actually different, distinguishable. So existence of consideration distinguishes a contract from a gift. There are 2 different things, okay, from the legal perspective here. Because why? A gift is a voluntary and gratuitous transfer of property from one person to another. And then without something of value promised in return. So it's only one way. In the here, A give away the property to B, and B give nothing to A in return. So it's only one way, right? And then it is voluntary and gratuitous. I mean, nothing in return. From donee towards dono. Only dono give away to the donee. And then, all right, this is actually the aim or objective. Okay, if we look further, if we look behind the rule here, basically consideration is important, is significant because this is the ordinary means, ordinary ways for justifying the enforcement of the promises by the parties. Meaning that here, this is the way to justify why we should enforce the promises, okay, between the 2 contracting parties here. But whenever a gift is made, okay, usually it's not really a bargain because it doesn't involve 2 ways. It's not 2 ways, it's only one way. So bargain for exchange is lacking. And because of that, okay, most of the time the promises, whenever it relates to gift, they are not enforceable. So failure to follow through on a promise to make a gift is not enforceable as a breach of contract, meaning that here, it doesn't give right to cause of action for breach of contract. Because why? There is no consideration for the promise from donee towards dono. Let's say dono change his intention or his plan later. So donee cannot sue for breach of contract because why? There's no contract between them. Okay, in the eyes of law. Okay, there's no exchange of promises. There's no exchange of consideration between them. Okay, we are done with the meaning, okay, with the definition. Now we go to types of consideration. So there are 3 types of consideration. Okay, we have executed. Actually, it relates to or refers to present. Okay? And then we also have executory, future, and we also have past consideration. But for this part of the lecture, okay, because I'm going to divide it into few short videos, okay, short parts of the video. We're going to cover executed and executory, and parts will be covered in the next video. We go to the first one. What is meant by executed consideration? So executed consideration, it refers to something, okay, which has been done or which is made in return for the performance of an act here. So actually, if it relates to section 2D, yes, this is actually, it describes thoroughly, okay? I mean, it refers to executed consideration. So I mean, let's go to the situation or example here. For example, if one party makes a promise in exchange of for an act by the other party, the moment, okay, whatever they promise between them, the moment the act is completed, so the consideration between them is considered as executed. It is considered as executed. It's done actually. Okay, executed consideration. Example here in a unilateral contract. Okay, for example, A offers £50 reward, okay, for the return of a lost handbag. So let's say B, if the B is the one, okay, who takes up the offer. So B finds the bag and B returns the bag. So the moment B completed the performance here, returning the bag here, so B's consideration is considered as executed. It is done. Okay, performance is done. So if you still remember, we discussed the case of Carlyle and Carbolic Smoke Ball Company. So if you relate to the facts here, when Mrs. Carlyle purchased the medicine, the smoke ball, and then he suffered from flu later. Okay, so on her part, actually, consideration is considered as executed. So he can proceed. She did proceed to claim for the reward, but the claim was denied. That's why he brought the case to the court. So it's quite straightforward here, executed. The moment the act is done, then it is called as executed. It is done. Okay, it is performed. Now we go to executory consideration. What is meant by executory consideration here? So executory consideration, it refers to mutual, both parts, okay, both ways, mutual promises of either party to do or give something in the future. Okay, so that's the meaning of the word executory, to be done in the future. So consideration is called executory where there is an exchange of promises to perform acts in the future. For example, it says, okay, I will deliver to you my car after you make the payment. So the act of delivery the car, which is to be to take place in the future, this is what we call as executory, to be done in the future. The moment it is done, okay, executory can be converted into executed. Okay, from executory, it becomes executed. So I put here example, a bilateral contract for the supply of goods whereby A promises to deliver goods to B at a future date, okay, and B promises to pay on delivery. So if A does not deliver them, then this is a breach of contract, and B can sue because A promised to deliver. And then the moment A delivers the good, so his consideration then becomes executed. From executory, it becomes executed. So both types of consideration here actually are valid, enforceable in the eyes of law. And then let's have a look at section 2D we have read. Okay, we are going to have a look at section 2E and then illustration A of section 24. So let's go back to our Contracts Act. 2E. We need to scroll up again. 2E, sorry, 2E here. Right. Every promise and every set of promises forming the consideration for each other. So it is an agreement. Okay. And then we go to section 24. Okay. Illustration A. Okay, this is section 24. It talks about what considerations and objects are lawful and what not. We go to the illustration here. Okay. A agrees to sell his house to B for 10,000 ringgit Malaysia. So here, B's promise to pay the sum of 10,000 is the consideration for A's promise to sell the house. And A's promise to sell the house is the consideration for B's promise to pay the 10,000 ringgit Malaysia. So these are all lawful considerations. So both A and B have different part, okay, of the different way of performing the contract, different act. Okay, to perform. So before they perform, it is executory. The moment the act is done, is performed, then it becomes executed, and they can sue each other if any of them, either of them, actually here breached the contract, did not perform. For example, it's possible to sue. Okay, we go back to our slides here. Okay, let's have a look at the case. This is a judgment from federal court, not really recent one, but the value of the decision is high. Okay, the weightage here. The case name is K. Murugesu and Nadaraja, reported in year 1980. And actually, this is an appeal from the decision of the High Court, okay, to order specific performance of an agreement in writing. What happened between them? So we have the appellant. Who was the appellant? The appellant was the landlord. And this landlord, the owner of the house, okay, he agreed to sell his house to the respondent. Who was respondent? Respondent was the tenant. Okay, and actually the tenant really wanted to own the house. Okay, he really wanted to purchase, okay, to buy the house from the landlord. So respondent was greatly desirous of owning the house because he had been staying there for so long. Okay, so he kept on pestering, okay, nagging, okay, the landlord into selling the house to him. And then the landlord actually did some scribble, okay, some writing. So the agreement, something in writing, okay, is on, but it was done, it was reduced into writing on a scrap of paper on which the appellant had written. So this is what the landlord wrote, okay, on the paper here. The date, it started with the date, 2nd January 1972, and then it is stated clearly, I agree to sell my house, okay, blah, blah, blah here, to Mr. A. Nadaraja, okay, the present tenant, of the house at $26,000, okay, within 3 months from the date, okay, from 2nd January 1972. And SJD is signed, okay, signed, registered owner. So the owner signed this piece of paper, but later, okay, nothing happened. Okay, nothing turned on the communication of the offer to sell from the appellant to the respondent. And then mean that here, basically, argument was that, okay, there was an offer and acceptance, okay, of the offer to constitute the binding contract. And then from that piece of paper, we can conclude there was an offer and there was an acceptance, okay, on the part of the buyer, the tenant here. But during the appeal, okay, one of the contention, okay, one of the argument put forward by the counsel for the appellant, they tried to argue that there was no consideration for the offer to sell. Because why? The agreement was void as being without consideration. So that's argument by the counsel. But the court said that, well, as far as consideration is concerned, okay, there are two types here. Okay, but for this particular case, from the facts here, the agreement must be seen as to be a case of executory consideration. It is to be done in the future. Okay, a promise is made by one party in return for a promise made by the other. So in such a case, each promise is the consideration for the other. So here, the significance of this case is that the court actually explain clearly what is meant by the word executory consideration. And then the court also went on to say the question of consideration was of a very elementary, was very, very fundamental nature. And then, okay, here, but his contention, the counsel contention, okay, on the part of, on behalf of appellant, that there was no consideration was entirely unfounded. No basis to argue that there was no consideration. There was offer, there was acceptance, there was intention between them, and consideration is to be done in the future, executory, which is actually valid, okay, which is enforceable in the eyes of law. So the court could not accept the contention that there was no consideration between them. There was actually, even though it is executory, to be done or to be completed in the future. We have a look at another case here. Wong Hon Leong David and Norazman bin Adnan, reported in the year 1995. And this is a decision by Court of Appeal. So who was the appellant? The appellant was a director, okay, of a company known as Wealth Sendam Berhad. And the company, Wealth Sendam Berhad here, they intended to develop its agricultural land into a housing estate. So because of that, they need to convert, okay, the status of the land. So they need to submit proper application to land administrator, and they also need to apply for subdivision. Okay, and as a matter of fact, in Malaysia, those applications, okay, it will take a long period of time before you can get the application, usually more than a year or maybe 2-3 years here. So in order to obtain speedy approval, okay, faster approval for the application, so the appellant, he sought the respondent's assistance, okay, get some help or assistance here, and they had a verbal agreement. So here, appellant verbally agreed, okay, to pay respondent a certain amount of money here, which is quite a big amount. 2,668,000, okay, K lah, all right. This is a big amount in year 1995, okay, 1990s, for his services to get, okay, the faster approval for the application. And then following that, okay, respondent wrote a letter to Menteri Besar. This is the act by the respondent, okay, in order to get the approval, the faster approval. Wrote a letter to Menteri Besar, okay, asking for early approval. And the Menteri Besar actually made a notation, okay, certain word here, okay, verification on the letter, telling the land administrator that he was supportive of the application, and actually within a year, till less than a year, some 8 months later, application was approved by the state authority. And then appellant paid respondent initial 100,000, okay, after seeing the Menteri Besar's notation, okay. But later, appellant said, no, I'm not going to pay you the balance, okay, 100%, and that's it. So now the respondent is claiming for the balance, okay, and also additional 100,000 ringgit Malaysia for resolving the problem regarding access to the land. So I mean that here there's a problem with the land, so he helped to resolve the problem. And appellant argued, okay, this is one of the argument. He said, well, oral promises, because there's nothing in writing here between them. So oral promise was unenforceable because why? It was because of the lack of consideration. I mean, here there's no consideration between them. Okay, lack of consideration. But the court held that, the court disagreed with the contention. The court held that it is not, this is a very strong wording, it is not, and it has never been the law in this country, in Malaysia, that to support an agreement, consideration must always be executed. So executory consideration suffice. So it is as valid as executed consideration. Whatever things you promise in the future, yes, it is also valid. You promise to pay in the future, you promise to pay once you get the approval, then it is also valid because it is executory and later it becomes executed the moment the payment was made. Okay, we stop here. We are going to continue with the past consideration in the next part of the lecture. We stop here.